What begins as a routine surplus funds hearing quickly turns into a heated legal battle over who is entitled to more than $100,000 left over after a foreclosure sale. Judge Melissa R. Mogen is faced with competing claims, newly filed legal documents, and an
Mr. Hanson, who are you?
I'm
Woza.
attorney Kyle Hansen. I should have a appearance that was filed uh, maybe minutes ago or earlier this morning. I was recently retained on the case.
On this case?
Yes.
And I don't know where you're from. I don't know who you are. I don't have a notice of retainer, and it's not instantaneous. If you file something, it should be more than 5 minutes before a hearing.
I very much understand it was last minute, Your Honor. My apologies. I'm attorney Kyle Hansen. I'm in Madison, Wisconsin. I'm a Wisconsin, amongst other places, licensed attorney.
All right. Our clerk is indicating that we may have just received it in our electronic system. It does take, it's not instantaneous. I don't even believe it's instantaneous in Madison. All right.
It might be slower down here, Your Honor.
Well, we do have Madison internet here, so our services are from Madison, so could be. We will go on the record in the matter 24 CV 115 U.S. Bank Company or U.S. Bank Trust Company NAS trustee of trust versus Gregory Allen Maley et al. Appearances are we do have appearing in person. We do have counsel Knut Norenberg for Mr. Maley. We do not have the plaintiffs here. They are not needed. This is a surplus funds hearing. We have Mr. Maley appearing in person as well. We have Kyle Hansen, newly retained attorney for Marcia Geisenheiner. And we are ready to go here today for the surplus hearing. I have received the filings, the refilings from attorney Norenberg. I believe he assured the court that they have been sent to Ms. Geisenheiner through her daughter, Ms. Jacqueline Van Kuren. Mr. Hansen should have access to those documents. He should have either been given them prior to by Ms. Van Kuren or Ms. Geisenheiner, and or he should be able to receive them electronically if he is opted in. Mr. Norenberg, what is your argument? This is your hearing, so well, your argument for the surplus funds, so you may proceed.
Thank you, Your Honor. As far as the third-party purchasers, they lack standing. They were not an original foreclosure action, nor did they hold liens on the mortgage premises. As far as Marcia Geisenheiner, the submission of surplus claim came through a non-attorney power of attorney, which constitutes the unauthorized practice of law. Consequently, we argue that the creditor has not made a valid appearance in the surplus hearing. Despite the potential security interest, the creditors failed to appear, I guess, up until this moment through legal counsel, but still have not brought forth a claim of surplus funds. The quitclaim deed in question, or that my client executed, gave a security interest. The express language shows the intent of the security interest. Although the deed may express such an intent to secure the debt, the deed alone is missing material terms. There's no signed note or any documentation specifying the amount owed, interest terms, repayment conditions. The burden is on the creditor to specifically prove indebtedness. However, the creditor has not been able to tell us how much is owed or provided any accounting tally or clarification on that debt. Despite all of this, Mr. Maley in good faith still believes the extent of his debt is $26,000 and continues to offer that and even memorialize this understanding by signing an agreement with Marcia on August 28, 2025.
All right. Well, arguably, wouldn't you say that Ms. Geisenheiner, even though she may not have herself put in a notice of claim, she at least appeared at the last hearing on October 13th and reaffirmed her request for a claim?
Yeah, I can buy that, but at the same time, there's been,
It doesn't really matter because your
Yeah.
argument is that Mr. Maley is willing to agree to, even if it doesn't pass legal muster completely to the stipulation, but he will abide by that and will,
yes, it's important to him to honor that to his sister despite
all right.
any
okay.
shortcomings.
Thank you. Mr. Hanson?
Thank you, Your Honor. I did get a copy of the petition for surplus filed by Greg Maley through his attorney. It's document 68 in the file, and some of its attachments, including the quitclaim deed. I think the legal effect is largely as stated, which is it says it's a quitclaim deed. It says it's an interest conveyed as security for debt owed by the grantor to the grantees. And therefore, the question is about how much underlying debt would be owed to Marcia, or it was to Marcia and Richard, her late husband. And that's the question. And my position is that we need to do discovery based on my investigation on this to quantify the exact amount owed. Specifically, a lot of money was loaned from Marcia and Richard from their bank accounts to Greg. And those records are more and more difficult to come by the further back you go in time. And we need the time to do not just the either bank requests specifically from the owner Marcia or subpoenas. I usually do both because sometimes you get better information on one or the other. But that's what the case, in my view, comes down to. I think we do have an agreement that some money is owed, and there was a quitclaim deed, and it does attach to the surplus claim, and there needs to be a quantification, liquidation, an exact appraisal of how much is owed on that. But that we are entitled to discovery more specifically. Greg must have some reason. He says, by his attorney, in good faith, he believes the extent of the debt is $26,000. There's going to be some basis for that. If there's simply his recollection, if there's some records, I'd like the opportunity to ask him about those things and to have him produce those. And then specifically on our end, Marcia can ask through her power of attorney for the information that are available from the banks. We've asked for that, and they said that they have more difficulty getting things over 7 years old. But because the accounts are still open, I'm hopeful that we will be able to get more. In short, we're looking at, Marcia and Jackie believe that it's more like $190,000 that was owed. Half the amount of the surplus would be a bit over $100,000, like it's $114,000. And then we have the settle amount of $26,000, and not to get into the substance more than necessary, Your Honor, but the parties have been engaged in some settlement discussions to see what they can do between those two. So based on all of that, my request, Your Honor, is to reset the hearing for after we have the opportunity to do that discovery.
Mr. Norenberg, rebuttal.
Yeah, I don't think there's any good cause for delay at this point. This is the 6th hearing for surplus. And I even got a reprieve last time off of something that was on me. I mean, you were clear at that hearing that there'd be no further extensions. They had their time to put it in. Let's see, the foreclosure was Marcia would have originally been served the foreclosure in September. The sale was May, or that's 2024. The sale was May 27th, 2025. on May 30th, that motion, I mean, they've had time to get an attorney. They've had time to do these things.
This is the legal turning point of the hearing. Judge Melissa R. Mogen explains that the court has already conducted multiple hearings over the course of more than a year, and every party has had repeated opportunities to participate and retain legal counsel. Although attorney Kyle Hansen has only recently entered the case, the judge distinguishes between his late appearance and the long procedural history already before the court. In civil litigation, judges have broad discretion to deny additional continuances when they determine that the parties have already received a fair opportunity to prepare. That principle becomes central here because the request for more discovery must be balanced against the need to bring lengthy litigation to a conclusion. What do you think? Should a newly hired attorney receive additional time, or should the court move forward after so many previous hearings? Let's return to the courtroom as Judge Mogen announces her ruling.
Or, months and years, I'm asking for the amount of time that it would take the bank to get those records. And more specifically, I've experienced doing exactly this, making sure that we get those exact records, asking them for them in the right way, and making sure that it's done.
All right. Thank you. This matter has been going on since September 13th of 2024. Ms. Geisenheiner had actual notice of this proceeding. She was served a summons and complaint. She was here along the way, or could have participated throughout this entire process, and has not done so. Mr. Maley has been available and has made himself known throughout this process. We had multiple hearings on this matter as it related to surplus. The court was very thorough with Ms. Van Kuren as it relates to the fact that she cannot represent Ms. Geisenheiner in the matter, because that would be in the essence of practicing law without a legal license. She may have certain powers of attorney, but to actually practice and argue is not one of them. To retain an attorney to do so, as she's done now here today, is. Through multiple hearings, even if those hearings were not actually on the record and they were adjourned to a different date, the court did advise she needed an attorney. And I believe at least on 3 of them, she had said that she was seeking an attorney. This is the first, I believe, that she has actually had a Wisconsin licensed attorney to be a part of this. I think she was seeking another attorney outside of the state, and the court indicated that that attorney must be licensed in the state of Wisconsin or pro hac fiche in order to be able to practice and argue in this hearing. This has taken a long time. This has been well over a year for this foreclosure. And I have no reason to believe in any argument. And I understand, Mr. Hansen, you are newly on this case. This is not any reflection upon you or your practice or your being up to speed on this, because you are doing what you have available to you and arguing with what you have here today. But because this has been going on since September of 2024, and Ms. Geisenheiner could have been involved in this matter throughout, and the court did not hear anything from her until sometime after the sheriff sale, and that we've had 6 hearings in this matter. The court is going to proceed with the surplus hearing, and based upon the documents that have been provided, even though they are argued that they would not pass complete legal muster, they are stipulated to that at least $26,000 is owed to Ms. Geisenheiner. The court hereby is going to order that $26,000 is ordered to Ms. Geisenheiner through the agreement that has been reached with her brother, Mr. Maley. The remaining amount of the surplus will be turned over and released to Mr. Maley. The court has reviewed the documents provided along with that quit claim deed and the stipulation or settlement agreement reached, and there could have been more argument. Again, Mr. Hansen, you are doing what you have available to you and using what you have available to you, but based upon all of the information the court has here today and any of the statements that have been made in the previous hearings from Ms. Geisenheiner herself, as well as from her daughter, Ms. Van Kuren, the court finds that $26,000 is what is owed to Ms. Geisenheiner through the surplus funds. So all other funds will be ordered to be released to Mr. Maley. As far as the arguments made or the alleged claims made by the individuals who have purchased the home through the foreclosure sale, those are denied as well. That should be through another action, if any at all. It is an as-is sale. They should have known that. They knew that, and they purchased the property. But regardless, if there is any action that they believe or claim that they have other avenues to go. This is not the route. All right, thank you. Then we are adjourned.
Your Honor, I need to make my record on
You sure may.
my response. So I think the court should reconsider and deny the petition for surplus filed by the co-owner that was filed October 10th of 2025. Regardless of the prior number of hearings earlier in the foreclosure or even regarding the surplus, that petition and is what's in my view on to be decided today, and that petition does not have has not had enough time for investigation and the like for us to respond to. That was earlier this month, even 17 days ago. More on the evidence of the underlying point, I proffer that Jacqueline or Marcia could testify as to the amounts that were loaned to Greg, and also that I could call Greg to testify as to the amounts that.
Well, I'm going to stop you right there. Let's do it. Let's have, if you want to have a hearing, you want to question them, let's go ahead and do it right now. That's what this hearing is for. We were here at the last hearing on October 13th, in which the only reason, the absolute only reason the court adjourned it to another date and time was not so that Ms. Van Kuren and or Ms. Geisenheimer can get an attorney, can actually retain a legally licensed practicing attorney in the state of Wisconsin. The very only reason it was adjourned is because Mr. Norenberg only e-filed the documents and did not personally send them to Ms. Geisenheimer and or both to Ms. Van Kuren, not to allow another adjournment for an attorney. So if you want to proceed and you want to have a full hearing here today, I have Mr. Maley here. You may question him. You have the absolute, I will give you all the time you need or you want here today for this hearing. And I will have Mr. Maley come up here and you can question him all you want. And then we can put Ms. Geisenheimer on the stand as well.
I would do that, Your Honor, but I would also ask for the underlying bank records that he has, that where he received funds from his sister Marcia, and unless he has those here presently, the hearing would need to be adjourned so that he would be able to
I disagree.
those.
I disagree. Do you want to have him under oath and to question him, because this is your choice right now? You have that option.
I would like, Your Honor, just a couple of minutes to confer with my client on the topic, please.
You sure may. I will send you into a brief breakout session.
Thank you very much.
Well, actually, that's not your client. Is Ms. Geisenheimer there?
No.
She's not present. And I don't know if I have an accurate or an effective POA. I have a revocation of a POA, but I don't know if there's a legally binding or enforceable POA at this time.
My apologies, Your Honor. I have in the petition the statement of admission that that Jackie was the POA through August 28th, 2025, and then some 5 days later, on September 2nd, Marcia signed a new POA reappointing Jacqueline Marie Van Kuren. That's page 1 of the.
Yes, I understand what's in the petition. I don't know if I have an actual updated POA. I had the old one, which was provided to the court. Do you have a copy of that enforceable, legally binding POA that should be in existence?
I believe so. But in any case, it is Jacqueline Van Kuren that I'm
Judge Melissa R. Mogen ultimately concludes that the hearing should proceed based on the evidence already before the court rather than granting another lengthy delay. After reviewing the recorded documents, the settlement agreement, and the history of the foreclosure proceedings, the court orders that $26,000 from the surplus funds be paid to Marcia Geisenheiner pursuant to the parties' agreement, while the remaining surplus is released to Gregory Allen May. The judge also rejects unrelated claims from third-party purchasers, explaining that any such disputes must be pursued through separate legal proceedings rather than this surplus hearing. The decision highlights how procedural rules, timely participation, and documented evidence often become just as important as the underlying financial dispute itself. If you found this case as intense as we did, hit that like button, share your thoughts in the comments, and don't forget to subscribe for more powerful courtroom breakdowns.
Time, but then I never received an updated or reinstated POA. But I'll allow you to have a few minutes with Ms. Van Kuren, and it looks like she is digging very furiously through documents to try and find it.
Thank you very much.